All right. Hello, everybody. H-1B new proposed regulations were presented to us. I think today, made public today?
I couldn't find them on Friday, but I was able to find them late over the weekend. So yeah.
Made public today is to overhaul the, I guess it's called modernizing the H-1B regulations, to overhaul the H-1B program with a lot of changes that are very significant that we're going to be talking about. Of course, the breadth of the document is incredibly large.
Yeah, I got about 170 pages as in the way I printed it by printing the print button on the Federal Regulations website. So that's about how long they are. And I mean, Sam, we have a talk about this today. I think there's literally like 10 different talks about this in terms of the content in here.
Yeah, and we're going to keep it simple. We're going to talk about some of the highlights. We are going to talk about this more and more as time progresses. But we are going to give you a simple presentation today to highlight the important stuff and break it down for you so you have an understanding of what this regulation means to you. I'm Sam Shihab with Shihab Burke, and with me,
Brian Burke from that very same Shihab Burke.
We practice immigration law in the U.S. and throughout the world, focus on employment immigration law, and we also do family immigration. And today we're going to be talking about H-1B new regulations and its impact on you. Brian, is this the law today, or is this something that is going to happen in the future? Walk us through this.
No, okay, to answer your questions, no and maybe not.
So it is not the law today.
And may never be.
And may never be the law.
Yeah, we're dealing with regulations that have been proposed. So the way that the government generally makes regulations is they put out an idea, a version of what they want the new regulations, the rules that govern their work, what they would want those to be, and they put them out there for notice, and what they call notice and comment. Basically putting the public on notice that, hey, these are the rules we're going to implement, and give us your commentary on them so we can think about, well, did you think of something that we didn't? Is there something that perhaps we're not considering? Is there something where this goes terribly wrong, or something where everybody hates this? And that's that.
And that process is important for these regulations to become law. If they do not do the notice and public comment process and allow people to comment and respond to these comments and adopt the ones that are reasonable, these laws will be ineffective if they just throw them out on day one.
And I would mention,
and that's the U.S. legal system.
Yeah. And I would mention that these are literally available right now for anybody to make comment on. These are still new, but you can literally go to, I'm going to put that smart slide on the screen of this subject. You can literally go to, it's right here, regulations.gov, look for DHS docket number USCIS 2023-005, and you can find the actual means by which you can comment on these rules. Anybody who is a member of the public can do so. That's the nature of the notice and comment rulemaking. So they're out there. They're not real rules yet, but...
And you can write any comment, you can read about it, and you can just say, it doesn't make sense because...
Yeah.
Yes. So everybody needs to understand that these are today, October 23rd, 2023. Today, these are proposed rules, and these are not the law today, and they are open for commentary from the public, and then the government takes these commentary and can take a very long time.
This is very true.
Now, there is urgency a little bit because one of them deal with the H-1B cap registration.
Yeah.
And therefore, there is a little bit of urgency on the...
Well, yeah, next cap registration begins in March, in theory. So one of the things on their they say in here is, well, we think we can get to that in time for next year, but we may not be able to. We may actually put out, when we implement this new version of the H-1B cap registration, which I let something slip, Sam. It's part of one of the things on their list is the new H-1B, a revision to the H-1B cap selection process. So, Sam, perhaps...
I'm sorry, before you go through that, what's the likelihood that USCIS can split this, Brian, and go with the cap registration only and then later on for the rest of it? Because they have taken on a massive undertaking, and to get this H-1B cap before March of next year, it's...
Well, they say in this rulemaking, the sort of preamble to the rules, it says all the thoughts they make going into this is that we're actually working on this, implementing this right now. Even as, as these words are published, we're working on implementing this new version. So they express a little bit of confidence and like they're planning on getting there. So Sam, I got to say,
let's do it.
Well, no. I mean, we're saying these aren't going into effect yet, but I read a lot of actual final rules from USCIS, and I can tell you this: they don't often come along and go, "You guys were entirely right. These rules are terrible. We're not going to put any of these out there." I guess the other side of it. So these aren't rules yet, but these definitely give us a really good insight as to where the likely final rules are going to be going.
Where the ship is heading.
Yeah, we can maybe push it a little bit, but
move it a little bit, but that's where it's heading.
Yeah. So I'm going to put up on the screen, Sam, sort of my my menu list. Everything that they think covered in here, just so people can get an idea as to what the government is thinking about. Definition of H-1B specialty occupation. What degrees are relevant to them? Evidence required to show maintenance of status. The H-1B cap gap. They're making some changes there. Oh, my slides went.
Yeah, are you on the timer?
I don't think they are, but they went back. Maybe I pushed a button there.
Yeah.
H-1B cap registration, showing availability of H-1B work when you're filing an H-1B petition. Oh, and beneficiaries owning the H-1B employer, whether that's possible. All sorts of changes going on here.
So owning the H-1B employer, so people don't understand what I mean, having ownership interest in the company that files the H-1B application.
Yeah.
So that make it clear, because for me that's a very confusing
Oh,
terminology.
I mean, for sure. So there is, like I said, Sam, literally, even though these aren't final rules yet, there is probably 10 of these conversations of our talks here built into this.
That is, for me, my first reaction is massive to be able to reach before March.
Well, I agree.
Massive challenge.
I agree, but one of the things I say about it is this has been, like, changing these things has been on their quote-unquote regulatory agenda for years, even before they sort of lost their old policy in a court case. So I've been waiting for this forever. I'm very excited, Sam, even though there's some interesting changes I don't like proposed here.
Yes.
Let's get into them.
Well, let's get into them, but just to kind of let everybody know, we're not going to, the intention today is to give you the highlights.
Yeah.
Number one, this was released very recently, today, officially, and it's that thick, it's massive.
Yeah.
We've gone through as much as possible, so anybody that tells you that they know a lot about it really don't know a lot about it.
Yeah, I would say anybody who does know a lot but knows it like the back of their hand has probably wasted their time, because whatever it is going to change as well.
So anyways, so what's highlight number one, Brian, to share with everybody?
Change in the H-1B cap registration. Executive summary. Everybody knows, we talked about it in this venue here, that USCIS was concerned about multiple registrations and gaming of the H-1B cap system during this most recent lottery. And basically, they have come up...
A smart solution.
Yeah, and I'll sort of put the quote up there and read it aloud for everybody, so everybody gets the benefit. So, DHS proposes to shift from selecting by registration to selecting by unique beneficiary. Under the new proposal, each unique individual who has a registration submitted on their behalf would be entered into the selection process once, regardless of the number of registrations filed on their behalf. By selecting a unique beneficiary, DHS would better ensure that each individual has the same chance of being selected, regardless of how many registrations were submitted on their behalf.
Okay, so pause.
Yeah.
This is a paradigm shift.
Yeah.
It's a paradigm shift by USCIS, and said to everybody, and this is probably what I have been saying. I am going to have to give myself a high five, Brian.
Yeah.
I've been saying...
We'll be giving ourselves some high fives later, too. Don't worry.
Yeah. We've been saying that they're having rules for the employers and different rules for the employees, and they created the two-system process, and now they're in the middle trying to manage traffic on an intersection that they've misdesigned. That's basically...
I feel like I'm hearing like former city engineer Sam Shehab talking here. Yeah.
Right?
Yeah.
So they've created that problem, and now there's and now they want to police it, and then they said, we're done, we're not doing this. every person get one chance. We're done.
Yeah. So I'm going to state it another way. So let's say, this year, if somebody put in 17 registrations with 17 different companies, right, they would get 17 chomps at the bit, 17 opportunities to be selected in the cap. The difference this year is that 17 registrations with 17 different companies gets you one chance in being selected in the cap. They basically, one passport number, one name, one passport number gets one chomp at the bit, one chance of being selected in the cap. There's some benefits for the beneficiary. Obviously, nobody can increase their chances by going to multiple sponsors to register them. But it gives the beneficiary a little bit more power. Imagine if you had 5 different offers, 5 different companies that registered you on your behalf. They all want you. They all want to add somebody to their team, and you're a valuable person. Suddenly those companies are in competition. You are all going to want to file with the company that's giving you, let's say, the best chances of H-1B approval, as well as the best offer out there. So it puts a little bit of power back in the individual's pocket, I guess, is my take.
Okay. So one person filed 5 applications.
Yeah, 5 registrations. Yeah.
Registrations through 5 different companies, and one person filed 1 registration through 1 company.
Yeah.
This person and this person have the same exact chance of being selected.
Yeah.
Yes or no?
Yes.
Yes. So everybody's clear. Okay. However, this person have the potential of having more than 1 company apply or have these companies compete for him.
Yeah.
Whereas this person does not.
Yeah.
So multiple registration will continue to be alive, but it will not increase the likelihood of being selected, but it will increase the likelihood of being with the right company.
For you, yeah.
For the beneficiary. So it still empowers the beneficiary, but it does not increase their chances.
Yeah. So.
And that's a good system.
Yeah, I like this, but Sam, one of the topics we've talked about a lot during our during these sessions here and people were asking questions about was fraud.
Yeah. Our favorite topic.
How is USCIS going to know? And this is where we high five ourselves again. And people asked us, how would they figure this out? Literally, the things that USCIS demonstrated they were looking at is literally what we were talking about in this venue, 6 months ago, or about 6 months ago when we started talking about how do they find fraud. And I'm going to put up one of the tables that USCIS included. It's sort of their justification for changing the registration system. Put this one up here. So there it is. This is the last 3 fiscal years, including basically explaining, some of their highlights for how the numbers went up, right? And Sam, the almost funny number is this one right here. In the fiscal year 2023 cap year, largest number of registrations submitted for 1 beneficiary, 83. A single beneficiary for fiscal year 2023, 80 so that's last fiscal year too, I realized. So that's, not even this one.
Do you think USCIS had a conversation with this guy? How can a single person file for 83 H-1B? Do you think, it's insanity.
Well, Sam, I imagine if you put 10 people, 10 H-1B cap registrants in a row, and this guy, one registration, the 83 person, I feel like I could pick that person out of a crowd. I feel like they must be radiating energy or something because they somehow managed to get 83 different companies to register on their behalf. It's yeah. So. USCIS is aware of this of people who
they're definitely aware of that individual.
Yeah. Well, literally they say here's I lost my quote. Here it is. Here's what they say about this chart. DHS recognizes that simply being the beneficiary of multiple registrations is not necessarily indicative of fraud or misuse. We always said that during these talks, Sam. As beneficiaries may legitimately have multiple job offers by different employers that are not working together to game the system. It is worth noting that significant increase in individuals with multiple registrations in fiscal year 2022 and fiscal year 2023. For instance, here it is. While DHS is aware that multiple petitioners may submit registrations for highly qualified beneficiaries, it raises red flags if one beneficiary has 41 or 83 registrations submitted on their behalf, which occurred in fiscal year 2022 and 2023, respectively. So, yes, they have indicated that they are specifically aware of those, those people. And they also added, Sam, another chart that indicated, sort of how you increased your odds here. And basically,
That's a small one to read. I apologize, but if you can.
yeah, so,
Squint.
essentially, basically, it's a simple chart that sort of states the obvious, and maybe I'll just sort of glaze over it. The more times you are included in the cap, the greater you increase your chance of selection. So those couple of people for fiscal year 2023 that had 75 or more registrations, those achieved 100%. Those were all selected because, of course, they were, because they had 75 plus chomps at the bit. There you go. One other one, Sam, I think is worth noting. And again, Sam, we talked about, how do they find these things? How would USCIS, look these things up? And we talked about, well, they'd look up companies with, high numbers, and they would basically sort of compare groups of companies, right? To see, who has the same list, where are they shared, and how do they follow through on these? And conveniently enough.
So these most likely are real companies.
Yeah. Oh, yes. It is important.
So these are they didn't say that, did they?
It is strongly implied that these are real companies.
So company A.
Yeah, I'll put the chart up here. Oh, I already put it up there.
Yeah.
Oh, here we go.
Company A with 540 registration.
Yep. Got a selection count of 180, right?
So they've had 4 times.
Yeah. Well. So the way I read the chart, it's basically 540 company A, 540 selections, right? 540 registrations, 180 selections, but they only filed 4 petitions for those people. And this chart over here, number of common beneficiaries. So basically, 540 of their registrations were shared by companies B through M in this list here.
And these are the target companies.
Yeah.
So the way they identify companies, they look at how many petitions they've filed.
Yeah. For who? Yeah.
And it's an extremely high number, which is 540.
Yeah.
They had 180 selections.
Yeah.
But only filed 4 petitions.
Yeah.
That's a company completely is in trouble.
Yeah, that's like the high, only that many and only file 4, and then basically the later columns, it's basically what other companies registered for the same group of people, and essentially for company A, literally companies B through M in this list literally filed for the same 540 people.
Right. And
so it becomes clear to them. So if there's a company out there who their list, matches somebody else's list, I've literally, we said this right here. If your list matches somebody else's list, that's something the government's going to look at. And I guess maybe that's sort of a natural result of collusion. Yeah. That if our lists line up, well, why would we all file a cap? Well, why don't we just save ourselves the money and just file 4 here, 4 here, 4 there? Everybody. There you go.
So this is what we call in the law constructive evidence.
Yeah.
So is it constructive evidence, or what's the term? It's direct evidence, and the other one is
circumstantial evidence.
Circumstantial evidence.
Yeah.
Circumstantial evidence, right?
Yeah.
Because the numbers don't lie.
Yeah.
I don't care what you tell, what story you tell. When other companies file that many cases, you cross-file that many numbers, and you file so little. That doesn't make any sense.
So I'm going to put up on the screen basically what they said about these numbers real quick here. I had it up for a second there. The degree of duplication between the companies raises a concern that the companies are working together with each other to increase their chances of selection. This, coupled with the fact that companies routinely have over 150 registrations selected each year, but only file between 1 and 19 petitions, suggests that the registrations submitted by the companies for the duplicate beneficiaries may not have represented legitimate bona fide offers of employment. So, Sam, big change, cap registration, proposed entirely new system, which they say, if we go and read this, and I did, I read a whole lot of this. I'm still digesting it, but they say new registration system coming in the future. We think we can get it in effect next year. We're actively working on it, but it may take effect next year or in the future. We don't know when these regulations will finally take effect. But hey, look for a new system where it's beneficiary-centric, 1 registration per person. There you go.
That really takes down probably adds pressure on every person, because now the likelihood is low, but it at least puts everybody's mind at peace.
Yeah, I mean, as soon as you pointed out that example, this person with 5 offers and this person with 1 offer have the same chance, I immediately go, I don't like it. This person who is in extra high demand.
A person with 1 offer may not have the personality of going and shopping, and he could be a genius.
Well, I guess the point is no system will ever be perfect.
Yeah.
I could argue a relationship, but I understand
necessarily.
I understand. Yes, it's circumstantial evidence.
Exactly.
It could indicate that he's in high demand, or that he's very charming and is colluding with other companies.
Second item we want to talk about, Brian, maintenance of status.
Maintenance of status. So maintenance of status is an issue that affects everybody. This actually impacts more than just H-1B visas, but most of these regulations are about H-1B visas, but the changes will apply to other visa categories as well. It is a general requirement that when you are filing to extend your stay in the United States, that you give USCIS evidence that you are maintaining status in the United States. Well, it only apparently existed in the forms as a requirement, the form instructions. Show evidence of your maintenance of status. And if you're an H-1B worker, it might be show us your pay stubs to show that you are maintaining your status. But the new regulations proposed sort of elaborate on that list of what might be sufficient to show your maintenance of status in the United States. On that list is, let me see here, evidence of maintenance of status may include, but not limited to, copies of pay stubs, W-2 forms, quarterly wage reports, tax returns, contracts, and work orders. And
this is where it's going to be very controversial.
Yeah.
Because, concerns, Brian.
So I imagine somebody applying to extend their H-1B status when changing employers, right? And on the list of things is things that they may not have when changing employers. For example, if you're an IT consultant, you're going from a consulting company to a private employer, for example, you might not have contracts, statements of work, wage reports, or tax returns from your prior company to show that your work with that prior firm was legitimate. But this says, our list. This is on the list of evidence that may be required to show your prior maintenance of status, which, concerns me. It's evidence that people may not be able to provide. Now, when I read the regulation text, and I read the regulation text on this one, it says it's may include,
I don't care about may include. May include becomes shall include when they apply it.
Well, yeah, exactly.
Because you have to remind them every time that it doesn't say shall include, it says may include, and they're going to completely ignore it.
Yeah.
It has to have more affirmative language
Yeah.
that says other evidence, such as the employee not getting paid, against his will, the employee being benched when he's not. So what the heck an employee is going to be doing if they're benched? They get the call, your project has ended, we're going to stop your paycheck. Tell me, how can you put that person out of status because he doesn't have any of these things?
Well, yeah, exactly. I mean, that's the problem. It seems like this could be used by USCIS to try to sniff out past status violations during your period of employment.
Subject the employee to a tremendous burden of
employer
overreaching.
Yeah.
So this is going to be challenged, I think, and should be challenged. You guys, if you're listening to this is something that you should be paying attention to, because it has to be a little bit more balanced.
In theory, if these regulations go into effect, it will affect the way the evidence we put in our H-1B petitions when it goes out the door.
So what's availability of work? Bona fide job offer. What is this?
I don't know. I'm going to give you a Brian explanation, which is going to be a zombie requirement, Sam, as in one that has risen from the dead in this version of proposed regulations. If we travel back in time a couple years to some very bad times, or let's say worse times for H-1B visas, the government was always requesting, contracts, statements of work, letters, evidence of assignments, stuff so they could understand and make sure that your H-1B work that you're going to be doing pursuant to your H-1B that has been filed, your new H-1B is going to be the real deal, bona fide work, right? And, they are basically I guess it's worth pointing out that in 2020, about June of 2020, all of USCIS's ability to request those things was thrown out in a settlement based upon a lawsuit by a group called IT Server Alliance. Since about June 2020, it's been an H-1B paradise where USCIS doesn't ask us for contract statements of work, letters, evidence of project plans, that sort of thing. And per these proposed regulations, they are bringing those demands for documents back. They want evidence that you're going to actually have what they call, there's availability of work, and they say evidence may include contracts or legal agreements if available, or other evidence including technical documentation, milestone tables, or statements of work. Evidence submitted should show the contractual relationship between all parties, the terms and conditions of the beneficiary's work, and the minimum educational requirements to perform the duties. So sounds like contract statements of work and client letters all coming back to, and now put in the regulations so USCIS can clearly require them under the law.
And furthermore, uncorroborated in-house projects.
Oh yes.
That the part that you did not highlight. Uncorroborated in-house
Yeah, I'll put it up here.
Projects will not be considered. It's insufficient to establish that the claimed in-house work exists. And as you and I were discussing before we went.
Heaven forbid you're a startup, you know.
Well, yeah. I mean, we've discussed that. Are we back to the 6 months H-1B? You know, we've seen them as 1 week H-1B before.
Yeah,
remember?
back in late 2017 or 2018, where one thing's not made clear is USCIS going to be going back to limiting H-1B approvals for the amount of time you can establish availability of work.
So that is a question mark that is unanswered yet for us, but that needs to also be answered. That there should not be a limitation on time, but there should be evidence, general evidence upon finding. And then the last one, Brian, because we need to jump and take questions from people, is the specialty occupation piece.
Yeah.
So the specialty occupation piece looks like the Biden administration is taking language originally proposed by the Trump administration, and it deals with the language directly related to a specific specialty occupation. So the directly related is a change and narrowing the field of what is an acceptable degree for H-1B.
Yeah, the requirement, so basically H-1B positions are ones, to sum it up very simply, normally require a bachelor's degree, and this is talking about a change in what the related degrees for, what kind of degrees, in order for there to be a specialty occupation, there must be certain degrees required, and it kind of is a change to the scope of degrees that might work for that, right?
Yeah, it's the language minimum is the minimum standard for entry into an occupation in the United States.
Yeah.
So that's a standard.
Yeah.
Under the current law.
Yeah.
Which is, what are we doing here in the U.S. as the standard?
The bare minimum to get.
Yeah. What's the minimum? What's the standard here in the U.S.? And then you show that, and that's what you do. The degrees you show. And we will give you examples here in a minute. What this new administration, as the Trump administration, is proposing is to remove that minimum entry into the position standard into the directly related to a specific specialty standard.
Yeah.
By way of example, right now, more than 50% in the U.S. of U.S.-born individuals in the IT field do not have a degree in electrical engineering or computer science.
Yeah.
Okay. So clearly, the entry into computer science should not be requiring an electrical engineering degree or a computer science engineering if you follow the minimum standard, entry standard in the occupation in the United States. Because in the U.S., they take a lot of other occupations. You know, mechanical engineers, they take other people with master's degree in analytics, you know, et cetera, as acceptable. Yeah. Because that's what what we do here in the U.S.
Yeah,
okay?
and they're saying, well, we're going to eventually narrow something. If your degree is not directly related, we're essentially sort of cutting off some edge cases, perhaps in degrees that they might have previously.
A lot more than edge cases, because right now, statistically, Brian, even now, whereas 51% of U.S.-born, do not have a computer science or electrical engineering degree. Yeah. Now, H-1B holders, only 18% do not have a computer science and electrical engineering degree.
That number baffles me, but I'll take it,
Yeah, so even with the rule that says you can allow other than computer science and electrical engineering degree, you have a big problem in the way the government is carrying out the law.
Yeah.
Now they're even narrowing
I see what you're saying. So 51% of U.S. workers don't have a related degree, and which is, clearly it means it's a rodeo out there. Everybody.
It's
wider.
It's the industry.
Yeah.
This is what the industry needs.
And there's the 18% of foreign workers who don't. And what happens? That's really 18% of H-1B folks out there who have to ask questions about am I still going to qualify? Obviously, there's probably ways to qualify, but there are ways under the law to qualify based upon education and experience, for example. But they're definitely shaking things up on that front as well. Who qualifies for a specialty occupation position?
Yeah, the second example they propose here is chemists, I think, and I don't have it here. I don't think I have it here, but chemists, I do. 48% of chemists in the U.S. do not have a chemistry degree.
Yeah.
Okay, but have a related degree. Okay, so if you have directly related, okay, that can really be a problem because right now only 15% of chemists in the U.S. on H-1B do not have a related degree.
Yeah.
So it's even narrower.
Well, yeah, they're being held to a higher standard, and those 15% of people are, yeah.
Yeah. So that is going to be a point of contention with these new regulations because obviously it is setting a standard higher than what the standard accepted in the U.S. Now I'll throw in one last comment on this, Brian. The reason, though, the reality of the matter, the reason 51% of people in the U.S. Do not have a computer science degree and electrical engineering degree is because the demand for these positions is so high and the supply is so low
That's very true.
that is creating a
Demand
massive need that we're taking people outside that field to work in that field right now in the U.S. And not sure if that's good or bad. You can argue it both ways. That is a further assertion that this proposed tailoring down is going to hurt us here in this country even more.
In terms of our international competitiveness, our ability to track
because
international
we're now
talent.
making it even more difficult for people from outside the U.S. to come and take these occupations.
Yeah. Essentially saying, well, you can lower your standards for U.S. workers, but if you can't do the same for for foreign workers,
And this is just scratching the surface of these new regulations, and we may pick up a couple points and talk about it every now and then. But we've taken a lot of your time listening to us. Thank you for listening to us on this topic.
I'm excited about it. Yeah.
Let's change gears. Brian,
Yeah.
And let's take questions from everybody here. And I know a lot of people have questions. And if you don't have questions, we can talk about H-1B regulations.
Oh yes, there's more to talk about for sure. So when it's time to take our questions, we say, just by talking to us in this venue, sending us your questions here, it does not establish an attorney-client relationship because frankly, we don't have. Well, one, because it just doesn't. Two, when taking our answers here, understand that we only get a real little bit of information, a little point of light about you, and so much more information is needed to really give you good legal advice. And we would always encourage you to find an immigration attorney of your choosing and take a consultation with them to really before making any sort of important decision relating to your immigration status in the United States.
Thank you. And before you take the first one, I have a question.
Yes, sir.
If you have a green card pending, if you are prior to 2016, 2018, 2017, did not file your adjustment of status. Okay, been in this country for a decade or less, maybe, and you're getting close to the green card process. What's the impact of this regulation, potential impact of these regulations on that person?
Relatively low.
I disagree.
Oh yeah?
Oh, I disagree because the narrowing down directly related can be a big problem. They don't have an adjustment of status.
Yes, but they have now,
many years of experience,
which might be able to sort of bridge that gap between what your degree is and what your basically per the H-1B rules, they allow you to combine education and experience to get to a degree of equivalency. But they don't allow you to combine U.S. degrees and experience, though, to get to a equivalency under the regulations, do they?
I think they do.
They do? Okay, but maybe I'm mistaken on that.
Yeah, I think they do. But the combination has to be well documented. This is not something that it's a simple employer letter.
Somewhere out there, there's an owner of a credential evaluation service, or a college professor who's going, boy howdy, they're making it harder to get H-1Bs, and it's going to require more expert opinions.
The experience letter has to be detailed.
That's very true.
This is not, hey, he worked from here to here as a computer programmer, and he did a great job for us, and he was an exemplary employee. We highly recommend him for the job, and he worked 40 hours a week. See you later. No. This is going to have to spell out the exact duties and responsibilities, the level of work that they've done, the level of responsibility that they've done, and these letters has to be very detailed. And then you're going to combine them with your degree, and then you're going to have an evaluation that says, based on the combination, if you don't have, let's say, if you're in the computer field and you do not have
a computer science degree.
or an electrical engineering
yeah.
degree.
Yeah. Yeah.
So that, I think it has a serious impact on these people. Now, for those that have an adjustment of status, they may have crossed the line to the safer territory.
Well, sure. If you have an EAD, you are impervious to H-1B stuff, essentially. If you don't want to maintain your H-1B status, use an EAD. You take advantage of portability rules when you change employers. All good.
Since I have both hands,
Yeah.
I'm going to ask another question and we'll take it in.
Okay.
All right. So now, for people who filed their adjustment status, Brian,
Yeah.
and have a labor certification that's
Sure.
certified, and an I-140,
Yeah.
okay? If their degrees, let's say they're doing a computer science related degree, and their degree is in another field of engineering,
Yeah.
in the labor certification, would that impact, does this regulation impact this green card application?
Well, ask me because I know, because I read it, Sam. You didn't plant this question. I didn't plant this question with you, and you came up with it organically.
You paid me $100 to ask that question.
So in here, they say basically when they start talking about, they talk a lot generally about degrees. They say, for an IT job, well, actually they don't say for an IT job, but they say, electrical and electronics engineering degrees, they would qualify you likely for a lot of specialty occupations. IT, all sorts of, computer science related ones, computer programming, I imagine, but also, pure engineering, building electronics, that sort of thing. So you might end up in a lot of different companies doing a lot of different things with those. But they also say, like, if you have a general engineering degree and you put in your H-1B petition that, anybody with an engineering degree can do this, you're going to have a serious problem with us. And okay, so fine, that's not in labor certification context, but I know there's lots of labor certifications out there that say, any engineering degree.
So what does that do?
I don't know, but I always worry about, I don't know, I'm going to call it.
But this is H-1B regulations only.
Yeah.
So this does not extend to the green card.
Sam, you've never seen H-1B policy creeping into an I-140 petition? I have. But I say that facetiously. I know you have.
You know these are going to court, all of them.
Yeah.
You know these are all going to court without an exception, because the beneficiary is not going to spend 15 years in this country and just say, oh, you changed the requirements now after 15 years?
Yeah.
Oh, let me pack my stuff and take the first plane out of here. That's not going to happen.
Oh, so to be clear, what you're really thinking about is, let's say, 10 years ago, I had a labor certification that says my job as a software developer requires a degree in computer science, engineering, or an IT-related degree. And I've read stuff in this.
And my degree is mechanical
engineering. And I've read stuff in here that says, you think you'd have a problem for an IT-related degree
for H-1B.
For H-1B. Yeah.
For H-1B visa.
Yeah.
But I think your comment is well made. I wouldn't.
I'm not going to lose sleep over it at this
exactly,
point.
precisely. Yeah. I'm not going to lose sleep over it right now, and I'm not going to lose sleep over it in this Biden administration.
Yeah.
What the future has for us, we don't know.
Yeah.
And the problem is that these applications take forever to adjudicate.
Well, take about 10 plus years, yeah.
But on the positive side is, when does a job labor certification requirement goes into any conversation about adjustment status?
This is very true. Very true.
1 in 10,000.
Yeah, I'd say that's
Today.
probably not. Yeah, today.
Yeah.
But all it takes is something to happen overnight, because when there was a change, the prior executive administration came into sort of power, got control in the hands of Homeland Security in about May 2017. It was like the flicking of a switch. H-1Bs were being approved constantly with an incredibly high approval rate, and it went to significantly more negative H-1B decisions immediately.
Narrower time.
And
was the narrower time started with the Obama administration?
It basically got a little narrower. I mean, I started early in the Obama administration, I guess, right? And it got sort of narrower and narrower across time, and then the Trump administration came along, and basically the worst and most draconian version of the Obama era policies. Basically, they took those things to the absolute extreme. That obviously, yeah.
All right, so I ran out of questions. I have two hands. I have two questions. So let's take questions.
Yeah. Let's see what we got on the question front. From Pathik Patel. I received a 5 years EAD and AP renewal combo card last week. Priority date early 2014. Any update on H-1B stamping start date in the USA? So
right there.
yeah.
So that's because we have not seen it.
Yeah, practically. Thank you. We were looking for anecdotal data to see if, because we were hearing people not getting 5-year EADs and not AP approvals, and I'm glad to see that you got an AP combo card for 5 years. That's crazy.
Thank you,
yeah.
Mr. Patel, for sharing this information.
Yeah.
So everybody get to know that USCIS appears to be approving them 5 years on each. Now, the question here: H-1B stamping start date in the U.S. I think it's next year.
Pilot program for 2024 is what we saw in a posting on the U.S. Consulate for India's website.
Yeah.
Yeah.
So that's what we got so far. Not much more information.
Yeah. Let's see what we got here from Paul Cocohone. I'll apologize if I butchered the pronunciation. Hi guys, I have an approved I-140 in EB2 Rest of the World category. My priority date is 19th of August 2022. When do you think it will become current? Is it likely in this fiscal year? So visa bulletin, because I admit, Sam, that's the one thing I'm lacking for today's presentation. Is that the November one there?
October, Brian.
There we go. So here comes the November visa bulletin. I have it up in front of us right now. So the rest of the world, final action dates for sorry.
Rest of the world.
Yeah, rest of the world right now. Rest of the world is in July of 2022. And we last saw from the October to the July visa bulletin that crept by about a week, as I recall.
If you can drag and put it right here.
Yeah, we'll do it.
Possible.
No, that's a great idea. And now we can see Paul's question. Yeah. So with a priority date of August 2022, I think it's certainly possible in this fiscal year.
I concur.
We saw it move a week, and even if it moves, I don't know, a week, a month, which I can make no guarantee of course, but it seems possible within this fiscal year that you will get there.
Well, it's highly likely. That's our position, but who knows?
Yeah, I think you'll get an idea as to what kind of movement you can get in the visa bulletin when we get to the January one, which is when we expect to see more movement.
Yeah. All right. All right, Shai Su. Hi, guys. Worked at A, I-140 approved. Company B acquired part in 2022. Amendment approved with Company B. Congratulations, that's an accomplishment. If I return to Company A, do they restart my I-140 process? I-140 from Company A is still active.
Interesting.
So there may be a little bit of a confusion there, because if Company B is a successor of interest to Company A, okay, there's only one I-140 and one labor certification that, in essence, transferred to the new company. Now, Company A may still be in existence, but maybe the division that you were in moved to Company B, and that movement of that division precipitated the successor and interest transfer.
Yeah.
And therefore, in my opinion, you would need a new labor certification in the I-140.
Yeah, all the details aren't here, but I'm inclined to agree with everything you've just said there, Sam. I mean, I think the sort of red herring in this for Shai is that the Company A I-140 is still left approved. It's because nobody withdrew it. But as a practical legal matter, that I-140, if part of Company A got cleft off to form Company B, with that came your I-140 that was through Company A. Yeah.
That's a good question, by the way.
Yeah, a good one, a fun one for us as a bunch of immigration attorneys. Let's keep them going here, see what we got. From Venkat Abhinamadi. Can we file for I-131 AP renewal prior to current AP expiry, which would happen to be April 30th, 2023? I imagine that's April 30th, 2024 is when you're maybe...
Prior to 180 days of current AP expiry.
Yeah.
So can you file before 6 months, prior to the 6 months? You can always file it. The question is, would they take it?
Yeah.
Because it's a free filing. It doesn't cost you anything except pictures and the postage.
Yeah.
A lot of people say, oh, they're taking them. Some people say they're rejecting them. You can file them.
Yeah.
But the problem is that you can wait a long time before they say thanks, but no thanks. You filed it too early. So yeah.
Your mileage may vary. Can you say? Well, people ask the question: is it possible I can somehow hurt my case by filing that I-131? Yeah, I can't really I'm a pretty conservative guy, and I just can't really fathom that. They'll send you a rejection notice saying,
yeah, the only thing I would be interested into reading the attestation at the bottom, just to be on the safe side, just carefully read it and see if there's any language there. But that's kind of, I'm shooting 1 in a million.
Yeah, when you're referring to the attestation, look at the forms you signed for USCIS. You're swearing to you're agreeing to something when you sign those, and something I would want to think about before doing that is.
What does it say exactly?
What does it say? Are you certifying that this is a good faith case? But honestly, if they're out there accepting other people's cases, why wouldn't yours be in good faith?
I think so. I don't think there's an issue there.
Yeah,
You can file it. It's a question, would they accept it? That's going to be hit and miss, honestly. I mean, given the fact that it's for free, my guess is the chances of them rejecting it is higher than accepting it.
Yeah.
If there's a fee attached to it, the chances of them accepting
they do like their money. Yeah.
They like the money. Yeah. So that's where it's at.
Yeah. See what else we got here. From Ram.
Yeah.
Can I transfer a canceled without prejudice stamped H-1B visa? Is there any proposed rule using H-1B canceled without prejudice? So I think Ram here is referring to a visa stamped in one's passport that has been marked as canceled without prejudice, which is basically, something that fairly commonly happens. And, well, first of all, Ram, I will fully admit I haven't read every page of this yet. That wouldn't be in the in the scope of Homeland Security regulations, which these are. And
since it's a State Department question.
Yeah, that's really a State Department question. And so
but I just don't know how to transfer a canceled visa.
Yeah, I would, unless maybe we're not understanding the question, but if you see an H-1B visa stamp in somebody's passport that is marked canceled without prejudice, that visa's toast, right?
And there's nothing to worry about because it's without prejudice.
Without prejudice means, no problem reapplying again.
Yeah, it's not because you did something wrong.
Yeah, generally speaking, when it comes to a visa that is revoked, you can't really undo it, but you can always apply for another one. And without prejudice means, hey, don't worry, it's not a problem that we revoked this visa.
Exactly.
Yeah.
All right, sky limits. Processing time for EB-5 keeps increasing from 48 months to 48 to 55 months, and now 58 months for India. It means they are not processing anything. What's the right time to sue USCIS, which is acceptable? That's a good question, and the delay in process. It's a good question. Well, I haven't seen this lawsuit, but you're right. I mean, last time I looked at them, it was 55 months, and now it's 58 months. And when people come and talk to me, and they say EB-5, and I say,
what are your other options because something's faster?
As a last resort, there are advantages to EB-5, even though it's 58 months.
Current priority dates,
which is current priority date and Child Status Protection Act, because if you file with your child and they're accepting and it's current or dates for filing is current, then you can lock the child with the under the Child Status Protection Act. It may take a long time, but that's good news for a lot of people. Now, lawsuit. I haven't seen a lot of lawsuits for processing time delays.
Not for EB-5. Yeah. I mean, what I always worry about with any sort of, processing delay lawsuit, the answer is going to be, well, yeah, you and everybody else. It just takes a while, and that's that. When I hear of like a true outlier case, everybody else is getting theirs approved in 55 months, and I'm at 72 months, or pick your number. That's when.
But a lot of people say that these numbers are garbage, and you should sue earlier. I mean, just the fact that the government is taking 4 years to process a petition
where your visa's available
is not an excuse for you not to say, hey, writ of mandamus, government, do your job. I don't care. Find more people. You took my money. Do it. This is an unreasonable time.
Yeah, I can't help but thinking, considering the money, because one of the challenges that people sometimes face with, long processing times, the government processes, sue the government, but that's kind of expensive. If you have the money for EB5, I'd say it's maybe perhaps a more attractive endeavor because you might have the money
And if
kicking
they're
around.
outside the U.S., their ability to sue becomes a lot more limited.
That's very true. Yeah.
But if you're in the U.S. on a different visa, you're in a better position to sue, I guess.
Yeah.
Especially if you have an adjustment status pending.
Yeah. Sort of a follow-up from Skylimit.
I mean, 2 years, 3 years, 4 years, because if they won't process the posted time, will keep increasing. Yeah.
Yeah.
It's a joke. I mean, there's other processes that's taking 10 years. Asylum.
Yeah.
I mean, we don't want to talk about other things outside the realm of
the employment that we
but yeah, but there's other. I mean, the USCIS.
Well, everything's increasing. Advanced parole is cartoonish amounts of
55 months.
Yeah.
I mean, I looked at it the other day. I was talking to somebody and looked at the time. It's like, oh my goodness, how can I tell somebody this is a good option?
Yeah.
And they're shocked. Everybody's shocked, and they just walk away, just like.
Yeah. Well, yeah. Bring your fat money from abroad to the United States. We'll give you a green card
in 10 years.
What is that? Literally like 60 months. That's 5 years.
More than 4 years.
Yeah. That's close to 5 years. That is ridiculous. Yeah. So.
All right. So.
Violin channel. My spouse received AP for 5 years validity, so that's another one confirmed. I like to see it. Can she stay outside the U.S. for a significant time, say 1 year, and come back on AP? Primary will continue to stay in the U.S. on EAD status. Thank you.
There's nothing out there today that says you cannot do that yet. And I doubt that there will be anything that will say that.
I'll imagine the adjustment of status RFE though.
Why would they deny a dependent adjustment status if the beneficiary is here and working in the U.S.?
Well, yeah. Here's the scenario I imagine, Sam. Primary spouses hanging outside the United States for a year. They're having a good time. They maybe come back every now and again. Who knows? But primary and spouse get called in for a green card interview. And they ask you, where you're living. We say, we see you've been outside the United States for the vast majority of these last 2 or 3 years. Sure. I could see that generating an RFE as to your marriage bona fides, perhaps.
Living apart as a husband and wife is part of the 21st century culture.
Yeah.
A lot of people live apart because, this is my response, of course, to the officer, for a lot of reasons. Children wants to go to the school where their parents came from to have the same culture. The wife is going through advanced school. The wife's parents are sick and they're being attended to, etc., etc., etc. And I don't have a green card guaranteed on a priority date that's taking 15 years, and I'm not freezing my life and my children's life because of that.
I'm going to be the USCIS.
Mr. Officer.
I'm going to be the USCIS officer. I didn't ask for an explanation from you, counselor. I'm going to give an RFE on that subject. You'll get it within 6 to 8 weeks.
It's easy for you to get me on a technicality, but that's the answer my client would give me.
I have the power as an officer to ask for whatever I want, and you either give it to them, you make a great argument that it's not required, but odds are you're still going to give it to me.
But the legal arguments is my part.
Oh yeah. Well, yeah. No. Fun fact: if we get that RFE, we're going to be writing that legal argument, but. I'm still going to try to give those good marriage documents as well, because I'm not going to rest on that legal argument on behalf of my client.
I'm sure I'm not going to kiss up for an officer who is going to be asking obnoxious questions either.
Oh, believe me, I don't like it when they ask obnoxious questions, and they do.
Well, I mean, they're entitled. I mean, and we'll give them answer. But that's the bottom line: is people live apart not by choice. Yeah. People live apart because of necessity.
Yeah.
Well,
yeah. I mean, I think my final answer to that is
because the officer is living in his country, and he's lucky to have a government job with children.
Yeah, living in a very narrow view of the world. Somebody who's never immigrated before.
Many of them have open minds.
This is true.
But we've created the question. Let's move on to the next one.
Yeah.
Any chance EB3 India, founding dates reaching August to 2012 with fiscal year, have been waiting for the last 1 year. So, hey guys, any chance of EB3 India, I guess, becoming current for August 3rd, 2012, Brian.
So I presume, he's talking about filing dates. So literally, EB3 India filing dates for November 2023 are on August 1st, 2012.
I would say that will improve.
I am inclined. I mean, that's only a couple days difference. It
will improve. They have been conservative, and they're saying that every quarter we're looking at it.
Yeah.
I would say yes. There is absolutely a chance of August 3rd, 2012, this fiscal year.
Yeah. Definitely a chance, and I'd say potentially as early as January. Okay, I don't know what's going to happen on the January visa bulletin, but they've broadcast January quarterly is when things. Interesting visa bulletins can happen. And that's what we've seen, honestly, for the past fiscal year since this mysterious new person is in control of it.
Yes.
Yes.
All right. Ram, for you, Brian. Thanks for answering my question. Go ahead, Brian.
You mentioned reapplying again. Does it mean needing to go into the lottery, or is the lottery not required? I'm going to have to go back and see what Ram's prior question was here, because I don't remember a lottery specific question, but now I gotta reload our list here of questions, and it's going to take a minute for them to populate, and for that I apologize. Ram, can a transfer canceled without prejudice stamped H-1B visa? Is any proposed rule using H-1B canceled without prejudice? Okay, I think I maybe understand Ram's question a little bit more here. Essentially, maybe it's a question of cap counting. Do you think? You mentioned applying again. Did it mean we didn't apply? No, we did not mean applying again in the lottery. Let's clear that. And we do not know enough about the cancel without prejudice experience you've had. Yeah, that's a very good point. And if you've entered the U.S. on H-1B for 1 minute and you had some kind of an employment in the U.S. on H-1B, and then left and you had a stamping cancellation, then there's no lottery problem for you. However, if you're outside the U.S., never been in the U.S. on H-1B, apply for an H-1B visa, it was granted, and then cancel without prejudice for some reason, maybe you apply for an L visa or something. Yeah, exactly. The question becomes, are you subject to the H-1B cap? Yeah, which is a very wobbly legal question as it... Reasonable people will differ on that. Yeah. In my opinion, I would say not. I'd say he's not subject to the cap. Yeah, well, I would say maybe I think he should be, but I would say, practically speaking, USCIS likely does not think this individual would be based upon the limited information we have here. Yeah, based on the limited, but we just put in additional facts for our discussion. We love doing that. Yeah, so we're talking about maybe not Ram's question, but we're talking about the question. Yeah. H-1B approved outside the country, got an H-1B stamp, didn't come to the U.S. Then maybe I went back to the council to apply for a different visa, be it B visa or L visa or F1 visa, and they canceled the H-1B visa without prejudice. Yeah. Are you subject to the cap? I'm going to answer my part so you can challenge it. Yeah. No, I would say you're not subject to the cap. Again, I think you're cap not subject. You can get an H-1B stamp and come back to the U.S. Yeah, well, so basically what you would do is you would get an H-1B approval through a different company, get a stamp based upon that new approval, and come back to the United States. And USCIS should say you're not cap subject. I give it a very good chance of success on that front as well. Because the regulations talked about what's not H-1B cap and mention anybody with an H-1B stamp is not. Yeah, well, I believe I could have sworn they said you have to be otherwise gotten H-1B status. So I think it might be or otherwise. Yeah, gotten 994 or otherwise gotten H-1B status, which require stamping and entrance. No, not stamping. Only stamping. Only stamping? Yes. All right. Well, I'll trust your memory better than mine. You seem confident. But there's nothing in the regulation. I am confident on that one from my recollection. But then you will prove me wrong right after. Yeah, I'm going to start reading the regulations. Yeah. But there's nothing in the regulation that talks about canceling H-1B. Yeah, we can agree. I fully agree. Just because your visa stamp, so whether your visa stamp, the physical visa stamp in your passport, does not have a bearing on whether or not you're counted under the cap. I fully agree. It will not undo whatever you had before. That's the point I'm trying to make. Yeah, I would agree upon that because we don't know the reasons why Ram's visa might have been. Let's take the next one here. We're hitting the end of the hour, and I'd like to take at least 2 more. Yeah, let's see what we got here. Let's see. August 3rd, 2012, mentioned it, we're applying again. Here we are. All right. Laith Farage. Hi, my priority date is July 7th, 2023, EB2, rest of the world. Very recent.
Current.
Yeah. I have only 22 months relating on STEM OPT. Any chance to file I-485 before that? So let's talk about maybe start looking at EB2 dates for final action dates, because those are the ones, those are always available, right? And EB2, rest of the world filing dates are
July
15th, 2022, and you're saying your priority date is
July
July 7th, 2023. He's saying 2023. It's very recent, a couple months ago.
Yeah.
So
A year movement?
Well,
not impossible.
let us entertain the question if perhaps they accept dates for filing again. Dates for filing for the rest of the world, EB2, are in January of 2023, which would require about 6 months of movement. Yeah, we are in weird and strange times on the visa bulletin where everything is sort of seeming to cinch up and move slowly again because visas are just simply less available, and there does seem to be higher demand from the rest of the world folks. I think our answer has to be to sort of, let's see what the January visa bulletin says, and you'll get an idea as to what the rest of the fiscal year looks like. I
agree.
Yeah. Well, Sam, it is just past 7 o'clock here. Yeah. We seem to have neatly tied up the questions that we have available to us. So
Sounds
perhaps
good.
we neatly tidy up our presentation.
Thank you, guys. We'll keep talking and updating you on the H-1B cap legislation, its impact on you, regardless of whether you are in the H-1B process, F-1 visa. There's some F-1 regulations, by the way. Affect students. We'll talk about those as well. And so there's more to talk about in the next sessions. Until next week, Monday, 6 o'clock, you guys have a wonderful